Um, Hi, thank you for being here this morning. Thank you to also distinguished panelists, Ben, Gavin, and Carly. It's an honor to be here with you this morning.
I'm afraid we don't have a list of who you are. We don't know who you are.
Yes, I'm about to introduce myself, yes. Not on the program, but my name is Carey Shenkman. I'm a US-based First Amendment and human rights lawyer. I work for Michael Ratner, who's a leading constitutional lawyer in the United States, and also the president emeritus of the Center for Constitutional Rights, which is a civil liberties a nonprofit who sues the government. Is leading in the Guantanamo Bay cases, stop and frisk NYPD cases, and several other prison and human rights cases in the United States. My background, as I said, is in First Amendment law, and I got involved in these issues starting actually at the Center for Constitutional Rights with the court access litigation in Chelsea Manning's court-martial. So we sue to access court records in that trial and make them available to journalists and the public. And I also have a background in publications on the International Criminal Court and contribute to Huffington Post, Truthdig, and Alternate and various publications. So when I was figuring out what to talk about today, I think the fellow panelists covered very well the situation in Europe and the UK. I thought in terms of discussing fighting for new laws, it's important to not only consider what we can do to fight for new laws, but to also think about what the other side is doing, fighting for new laws, because it's not a one-sided battle. And certainly, if we look at what's happening in the world, there has been a strong push on the other side to fight for increased secrecy in the law. And studying around the world, we have actually seen an increase in sedition laws around the world, sedition and secrecy laws. And it's a problem that's getting worse and not better. For instance, Japan passed the Specially Designated Secrets Act a year ago, which penalizes the disclosure of secrets. You may have heard about a case in Ethiopia just a few months ago regarding the Zone 9 bloggers, which are several journalists and bloggers who are actually being prosecuted under terrorism charges just for attending a security training using security in a box, which is available just in this lobby. South Africa is trying to pass a bill called the Protection of State Information Bill, which punishes publication of state secrets with up to 25 years in prison, with no opportunity for a public interest defense. Some countries adopt very, very problematic language in their laws. Bahrain punishes destabilizing the security of the country. Vietnam punishes abuse of democratic freedoms. And that law in Vietnam has been used in recent years against several bloggers. And in my jurisdiction in the United States, we have a law that's nearly a century old called the Espionage Act, which was initially passed to prosecute dissidents and socialists in the United States. It hasn't been successfully used against a publisher. There have been several attempts now. The leading attempt is the ongoing criminal investigation against WikiLeaks, which is strongly suspected to be under the Espionage Act. And as we know, also the Espionage Act is what Edward Snowden is currently charged with 2 counts under. It is what was used to convict Chelsea Manning to 35 years imprisonment. And it is a tool that is used against whistleblowers. So in light of this, the question is what we can do about that. And the question is whether or not we try to pass new laws in opposition, or perhaps try to find ways to amend these laws and make them work more in the favor of whistleblowers. And that's basically the core of what I wanted to talk about today, which is introducing defenses into these laws. So we have secrecy laws that currently, at least in my jurisdiction in the United States, don't allow for public interest defenses. So what do we mean by public interest defenses? We need laws that acknowledge a whistleblower's right to argue that they are making disclosures in the public interest. And that means arguing in a criminal proceeding that disclosures serve a public interest, so that if I say that, if the government says that I deserve to be deprived of my liberty for making a disclosure and being punished, I should be able to present evidence that, no, I serve the public good. This would actually seem fundamental, but it's not a right in several of these jurisdictions. A whistleblower actually can't argue or introduce any evidence that disclosures help the public interest. Just recently, John Kerry and Hillary Clinton have called for Edward Snowden to return to the United States, arguing that he would receive a fair trial there. But this is actually absurd because he wouldn't, under the Espionage Act, actually be allowed to submit evidence of any of the following things. He wouldn't be allowed to submit that he showed that the NSA director lied to Congress. He wouldn't be able to show that new legislation and an unprecedented public and global debate ensued. He wouldn't be able to show that a federal court in the United States ruled several of the programs that he disclosed to be unconstitutional. But there is some sign of hope because there actually is traction in the international community and legal precedents that support the right to a public interest defense. And I think that's where we really have to start when we have this conversation. So in some jurisdictions, for instance, Denmark allows whistleblowers to avoid sanction for disclosing state secrets. Canada's Security of Information Act, or SOIA, punishes communication of special operational information, and it has a provision, though, for weighing the public interest of disclosures. And Australia recently passed something called the Public Interest Disclosures Act, which came into force earlier this year. Now, some of these other jurisdictions that allow for public interest defenses, they're not perfect and they have some flaws, some of them serious. Denmark's law has been applied inconsistently. Australia's law has huge exceptions for intelligence information, making it of limited use for national security whistleblowers. And of course, the Abbott government is currently seeking to prosecute, in one case, a whistleblower and his lawyer. In some cases, the European Court of Human Rights has ruled in favor of a public interest defense, although this case law is still being developed. And generally, the European Court has been deferential on national security matters to states. We can also look to the UN system and other international legal mechanisms for supporting a public interest defense for whistleblowers. So we can look, for instance, to the UN Human Rights Committee and its comments to the International Covenant on Civil and Political Rights. It said that governments must take, quote, extreme care to ensure that laws relating to national security are not abused. The Johannesburg Principles, drafted in 1995 by many leading international law experts, said that, quote, no person may be punished on national security grounds for disclosure of information if the disclosure does not actually harm and is not likely to harm a legitimate national security interest, or the public interest in knowing the information outweighs the harm from disclosure. And just last year, following the Snowden disclosures, a huge number of civil society, UN, and academic experts agreed on what were called the Sewanee Principles on National Security, which recommended that accused have a right to present a public interest defense in court. So the key here is really that individuals have a chance at legitimate due process and judicial review. And it's simply not fair for a whistleblower to be punished under a secrecy law if they don't even have a chance to submit evidence in court. It's not even a matter of that evidence not being considered properly, but it's a matter that if I come in the court and say that these disclosures serve the public good, that I should have a right to say that. But actually, in cases, at least in the United States, particularly with John Kiriakou and Thomas Drake, when they attempted to present that evidence, also with Chelsea Manning, when they attempted to present evidence that, no, my disclosures did good, the judge didn't even let them speak. They said, no, this evidence is not admissible. And the government has fought, the US government has fought feverishly on that point. So I would like to make just a few notes because it is a complex issue when we're speaking. I can speak about generalities, but when we're actually trying to implement such defenses, of course, they need to vary by jurisdictions, and there are numerous complexities that are being debated in academia. But there are a few considerations that I would put out there today for you to consider as you take away. The first being that while we want to provide a public interest defense for whistleblowers, we want to be very careful that we don't create a slippery slope where we end up creating a chilling effect on publishers of those secrets. So we don't want to say we're going to have a public interest defense, but that public interest defense is going to apply to publishers and journalists who then have to argue in court, no, my piece that I wrote actually serve the public interest. Please don't punish me under the secrecy law. My strong position is that publishers should have complete immunity outside of very, very narrowly crafted exceptions. Secondly, public interest defenses. I've spoken about whistleblowers. Actually, I maybe should have put this further up, but strongly urge that these defenses also apply to hackers and hacktivists, particularly if we look at cases like Jeremy Hammond's. We have to make sure that hackers who reveal information in the public conscience have an opportunity to present in court that their actions were done with the public good in mind, rather than being treated as is increasingly happening in the United States, and as I personally witnessed at the sentencing of Jeremy Hammond in New York, that hackers are causing anarchy, that they're causing chaos, that essentially every hacker is a black hat hacker trying to steal credit card information and cause great harm. But there is a little conceptual difficulty here, is that whistleblowers usually are insiders, whereas hackers tend to be outsiders entering a system. I think at the end of the day, a lot of the language that we see used to describe two categories are very similar, in the sense that whistleblowers are described in terms of betrayal. And I find that so are hackers in terms of betraying the public trust, except with, I guess, a layer, a rhetoric of trespass. But that's a little challenge that I don't think has been fully resolved yet, in a way to coherently make make the rules that apply to whistleblowers also apply to hackers. Finally, two more points. The third, the defense should acknowledge that a whistleblower has a right, a right to not pursue other channels if there's a reasonable belief that official channels are inadequate. And this is very important, because there's some cases where it's blatantly clear that pursuing official channels may not only be ineffective, but expose whistleblowers to a significant personal risk. And there should be a consideration that allows for disclosure, for defense in these cases. And finally, there's an important question, is who has the burden of proof? So I can sit and talk about having a public interest defense, but if, for instance, if the government can just come into court and present secret evidence that disclosures are harming the public interest, and there's no opportunity to actually review that or argue against that, then that public interest defense isn't doing much good, because none of those arguments are actually being heard in court. So the process must not only be open, but the burden really must be on the government to publicly show to rebut the claim that the public good is being served. So I think with the development and all the developments in the last year, it can be a little depressing, honestly. And I think being in the center of the legal issues, we have a lot of great developments in Europe, and it's going to be exciting what happens in the next few years. But the law tends to move slowly, and we see even with the European Court, we could be waiting several years for a decision, and the policy often moves faster than the law. And I think the most important point is to remember that the other side is very much fighting to get the law to move quicker, to not only maintain the status quo, but to turn it against journalists, to turn it against whistleblowers and hackers. So it's critical to make sure that, at the very least, if we can't pass new laws, we have to find ways to at least interpret the existing laws, these new secrecy laws, to make sure that there's opportunities to even argue a case in court. So thank you, and if there are any questions, happy to answer.